He has been involved in European and international human rights advocacy and humanitarian work since 2009. He also organized support for Ukraine's civil society during the Maidan Revolution, and has also coordinated support programs to help internally displaced persons and refugees in Ukraine. He has also led the Foundation's campaign to defend the rule of law in Poland. The floor is yours.
Thank you, Hanna, for the introduction. Dear Mr. President, I greatly appreciate the invitation to today's discussion, and also the Vancouver Declaration before on the role of national parliaments in enhancing the decision-making process, the participation of civil society in decision-making processes of legislatures. The declaration seemed to reflect a deep understanding of the necessity of partnership between civil society and parliamentarians in order to improve the lawmaking process. We believe that involvement of civil society actors is essential in strengthening the capacity of democratic systems, both at national and transnational level, to resist abuses and attacks of malign states, be it totalitarian, authoritarian, or hybrid regimes, as sadly today's Poland or Hungary. According to our experience, international institutions tend to be rather slow in responding to evolving challenges represented by non-democratic countries, their enablers and facilitators. To counter them, dynamic cooperation with MPs have become a key path to defend persecuted civic activists, journalists, opposition leaders, lawyers, disobedient prosecutors, Poland, for instance, inconvenient judges and business people and all those associated with them. Over 10 years, through close cooperation with OSCE PA members, MPs, the Open Dialogue Foundation, alongside other human rights initiatives, has been able, I would say, to protect hundreds of political prisoners and refugees across the region. And civil society efforts made OSCE PA the first forum addressing the issue of transnational oppression by hostile foreign powers, such as the abuse of Interpol, Schengen Information System, mutual legal assistance, or the abuse of AML, CFT laws, anti-money laundering, countering financing of terrorism, leading to financial exclusion of regime's opponents. Therefore, ensuring smooth access for civil society to sessions of parliaments and transnational institutions in order to update parliamentarians on emerging threats to democratic societies remain of vital importance. We believe that implementation of the recommendations 18 and 19 of the Vancouver Declaration would allow to greatly improve the cooperation between civil society and parliamentarians. Certainly, both national parliaments and transnational assemblies should establish supportive legislative framework for public participation. What are the main obstacles faced by civil society organizations in this regard, and what could make their work more effective? Allow me to focus on a couple of issues, please. I hope I won't be too straightforward and too technical, though. In general, rules of procedures governing access to parliaments, transnational assemblies and their works should become more transparent and less arbitrary. The system used by the European Parliament may serve as a role model. It is vital for a transparency register governed by a political body in charge of granting accreditations and issuing budgets to exist. In our view, obtaining accreditation should depend on meeting formal criteria, not rely solely on sponsorship by members or by MPs of a given assembly, or, for instance, in the case of PACE, the Parliamentary Assembly of the Council of Europe, an extremely rare discriminatory instance of having representation in 5 Council of Europe member states. It should be possible to renew it on an annual basis. The processing of applications should be continuous and allow access to all premises to facilitate in-person meetings with MPs and relevant staff. In particular, civil society representatives should be allowed without discrimination access to common spaces of parliaments and assemblies to conduct their human rights work independent of MPs, independent of being accompanied by MPs. Additionally, accredited civil society representatives should have the right to invite guests, such as lawyers, experts, or victims of human rights violations, to take part in their advocacy work, providing information on who will be invited and for what purpose. Relevant procedures should be developed for activists to attend meetings and sessions as observers. All procedures in place should have reasonable deadlines, and when an accreditation or their application is refused, justification and remedies. Obstruction of access to parliaments and assemblies such as PACE or OSCE PA premises and sessions remains a problem. We believe no member or no MP or a group of MPs should actively seek to prevent activists from entering premises where meetings, sessions and all kinds of gatherings are held. It should not be allowed to obstruct the work of civil society organizations because their views or agendas are not shared by some MPs. Attacks on civil society may also take the already mentioned form of defamation, slander, false and damaging statements by diplomats and MPs. Sadly, it's not uncommon to face unacceptable and unfounded allegations against civil society organizations and even MPs cooperating with them, formulated by other MPs in order to undermine such cooperation. Usually, diplomats or parliamentarians representing non-democratic states such as Russia, Kazakhstan or Azerbaijan, but recently also Poland, abuse their power to attack critical voices. It is no secret that our organization is conflicted alongside other organizations with the current Polish authorities over the issues such as the rule of law and humanitarian crisis on the border with Belarus. I would like to point out one example, one situation where representatives of the Polish pro-government political party, the ruling governing party, Law and Justice, led by MP Arkadiusz Mularczyk, who is also deputy minister for foreign affairs, tried to undermine our human rights advocacy work at PACE. We became a target for him and his colleagues, whose actions were harshly criticized in one of the resolutions on the independence of judges in Poland, adopted by PACE in January 2021, and that resulted in Mularczyk, supported by a British Conservative MP, his political ally, initiating a series of actions based on false claims to block our advocacy campaign at PACE, and he accused us of dictating anti-Polish amendments to the resolution and even to influence MPs at PACE in other ways, including allegedly financial incentives, bribery, to be blunt. Fortunately, his allegations were unfounded and resulted in Mularczyk's temporary disciplinary ban from speaking at PACE in June 2021. His aim was to obviously limit the influence of NGOs and exclude inconvenient activists from the work of PACE, and unlike the same lower chamber of Polish Parliament, PACE is not surrounded by fences and barriers, and its management, its leadership does not ban civil activists from entering it. As the speaker of the same and the commander the same guard do. Speaking of national parliaments, Poland is nowadays a prime example of, even in a very physical sense, of a closed legislature where rules are established and enforced by force at the arbitrary request of the speaker. And no matter how legally dubious and questioned by courts afterwards, the speaker just does as he wishes. It's been a few years since I've been to Sejm, so I don't know if it's still applicable, but around 2017, a blacklist of people, mainly activists, was introduced by the Speaker of Sejm, and those activists were banned from entering Parliament without any sound legal basis, just by order of the Speaker. What should be done to protect civil society against such attacks? The answer is accountability. Codes of conduct should include a prohibition of such actions and accountability mechanisms against this kind of abuse. Civil society representatives should be entitled to should be able to file complaints for review by an independent body, entitled to impose, or at least to recommend specific disciplinary sanctions. Furthermore, there should be a clear obligation for any individuals registering in transparency registers to reveal any links, professional dependencies on governments or state institutions under the sanction of removal from the register. There are very different standards of cooperation between parliaments and civil society. Speaking of parliaments used as a tool of persecution, Moldova, for instance, a couple of years ago, under the rule of Vladimir Prochotniuk, the time so-called the owner of the country, Moldova's parliament was used to initiate proceedings against the country's opposition and critical civil society organizations such as ours, and such actions, those actions resulted in criminal investigations being launched by the country's prosecution, and also in Poland since the end of 2015. There were instances of Parliament's works devoted to enact laws seriously limiting and restricting the rights of civil society organizations as independent agents of the public. There are very different standards, and if I had to single out, on a positive note, the most friendly examples among European countries, it would be Germany and Italy. Their parliaments, and amongst those not too friendly towards civil society representatives, it would be France, in terms of, for instance, organizing a meeting or an event at the parliament. It is much easier and smooth to do it at the Bundestag than at the French National Assembly. A separate issue, just to mention, is the practical blocking of accreditation at the United Nations, so-called ECOSOC recommendation, which is virtually impossible to obtain, and notorious it is blocked by countries such as Russia or China, and it constitutes an example of authoritarian capture of international organization. An important aspect is also the organization of observation missions to third countries and cooperation with NGOs in this regard. The composition of delegations or their agendas, it all should be known in advance, and NGOs should have the opportunity to meet with foreign politicians. Also important is the principle of limited trust. limited trust in undemocratic governments, which may promote their own so-called gongos, government organization at the expense of persecuted genuine civil society organizations. Last but not least, procedures and regulations are one side of the coin. The other is individual willingness of MPs to meet, listen, and get involved in defense of human rights, the rule of law, and democracy. And also, if I may, using this opportunity, I would like to invite you to our side event on Monday at 4 p.m. It is about the political persecution of activists, journalists, business people, and other figures deemed opponents by the current authorities in Poland. It's 4 p.m. on Monday. The room called
Saski,
I believe. Thank you very much.
Thank you for sharing also some concrete examples of the challenges faced by the civil society.